So let's talk about our first case, which is Walkovszky versus Carlton. So anyone want to help me through that one? Facts of Walkovszky. Which case was this, right? We have two big accident cases here. Ashley.
Sure.
Yeah.
So the plaintiff, Volkov was run over by a taxi cab that was owned by defendant Sion Cab Corporation.
Mm-hmm.
Defendant Marquez owned several cab companies that were operated independently of another. So as a result, he was operating with a minimum amount of liability insurance on each individual cab. So when the plaintiff was injured, their ability to recover their full damages was limited.
Great. You get hit by a cab and you think, all right, that sucked, but at least I can sue him. But how much money did this cab company actually have?
The company itself or the insurance?
Yeah, the cab, he was hit by a cab company, right? And well, it doesn't, in this case, it doesn't actually really matter much, but he was hit by a cab from Sion Co., and they had $10,000 of insurance. It doesn't, in fact, we'll see in the next case, at least according to the majority, whether it's cash or insurance, self-insurance or actual insurance, doesn't matter. Why did they have $10,000 of insurance?
It was the minimum that was required.
That was the minimum required by law. I want to come back to that concept because there are some arguments about policy that I think are worth mentioning here. And so, who did you say owns Sion?
Marquez.
All right. I'm not actually tall enough for this one. Seemed like a good idea at the time. All right. So, right, the cab company is going to be, the driver is Marquez, right? So we're going to put him, whatever. It doesn't matter. He's got no money either. All right? No, it was owned by Carlton. Now, what else did Carlton own?
Many other cab companies.
9 other cab companies. Yeah, many other cab companies. 1, 2, 3, 4, 5, 6, 7, 8, 9. Guy's got 10 cab companies. And guess what? They've all got $10,000 of insurance. Big surprise there. He has the minimum. Okay, so what's the lawsuit going to allege? What's the claim?
That it was an intent to defraud a potential court victim.
Yeah, so maybe I'll put it different. What does Walkovszky want?
Money for getting hit by the cab.
He wants money, right? And 10,000 is not enough. He gets his 10,000. He wants more money. Who has more money?
All of the entities as a whole.
This one, right? There's more money here. There's at least 10,000 aggregate in each of these. And we're going to assume Carlton is a wealthy dude. He's got a couple cabs. He's got money. He's been pulling money out of this enterprise. All right, so this is veil piercing, right? Because what is this? This is the shareholder limited liability veil right there. Does Walkovszky pierce Sion Cab's limited liability veil and get to Carlton's bank account? No, we don't have piercing here. Why does the court find that we don't have piercing? What does Judge Fold have to say? What is the purpose, Judge Fold says, is for veil piercing? He says the law permits incorporation of a business for the very purpose of enabling its proprietors to escape limited liability, but the privilege is not without limits. Have we reached the limits here? No, we haven't reached the limits here. So let's look at why. Well, first off, I should point out that there actually are 2 different claims. Right, I'm going to do my piercing up and piercing out. Carlton is up. Carlton is the shareholder. We always draw the shareholder, the owner, above the company. And so we have a type of piercing here that would go to the individual shareholder, but they also want to pierce out. And we're going to talk about piercing in corporate groups, but effectively, that's a different theory. So what is the name of the piercing out theory to the other cab companies? Enterprise liability, right? So we have 2 different theories at work. Enterprise liability and individual liability, piercing up. So did the court find that Carlton was, for example, Stealing from the company? No, he wasn't stealing from the company. Did the company find that Carlton was not observing corporate formalities? No allegations of corporate formalities. Did it find that Carlton was really not running a cab company, but driving this cab for his own personal transit? No, this is a guy who's really running a cab company. What was the only claim, the only factor that Walkovszky could maybe hang his hat on here? What was the only thing in our factors list that really jumps out?
That he was purposefully undercapitalizing the company.
Yeah, 10,000 is not enough, guy. You can whack somebody, and it's going to cost more than that for even a broken leg. You know, cabs getting it. They whack things. They drive around New York. I mean, forget about it. It's not enough money to be fully capitalized. But he was meeting his legal requirements. So let's turn to the dissent for a second. The court's opinion, by the way, Ken said that this was not undercapitalization. This was minimal capitalization, right? In fact, there's a statute out there. If he had 9,000, I think that, that probably would have been under, right? Not meeting a statutory minimum, but the court said he met his statutory amount. Judge Keating disagreed. What does the dissent have to say about this?
The dissent was looking at the intent of the legislators, and
Mm-hmm.
he basically said they were not intending to allow the defendant to organize his business in a way to avoid liability.
So this is interesting. I want to focus on this argument because I think it's dead wrong. Why do you think I think this is a bad argument? The argument, again, is that the legislative policy is that cabs should not be able to hurt people with impunity. Well, then why did they make the limit 10,000? I mean, if the legislative intention was that cabs have enough money to make sure that they take care of their damages, let's put another zero on that. You carry 100,000. Why carry $1 million? Or for that matter, that medallion you've got up there, why are you protecting that from lawsuits? I actually have a story for you about why they're protecting that from lawsuits. I have a video on that too. Let me see if I can actually get that up because I think this is a theory worth hearing. And while that boots up, I'll kind of talk about it. So I don't agree with the argument that there was undercapitalized. I agree this is minimally capitalized, but if the legislature wants cab companies to have more insurance, why not have the law require more insurance? I think that's why the majority was the better answer here. Now, of course, we feel bad for people, but we need a legislative solution. We don't need a judicial activist solution, right? We need a legislative solution. So what did Walkovszky want? Let's think about that. He wanted two things. He wanted the court to combine the assets of the cab companies. That's called enterprise liability. And he wanted to pierce the corporate veil to go after the individual shareholder because, this is important, the structure was an unlawful attempt to defraud members of the general public. Yeah. Now, what was the result here? Well, the result was, as you might expect, that it wasn't found because we didn't have those plus factors. We did have the issue that this is a closely held company, which is, I don't know if I'd call it a factor. That's more of an enabling condition. Without it being closely held, we don't have them. But I want to talk briefly about tax medallions. I want to share with you an economic theory, and I hope you can see the video. But it's mostly about hearing this guy. I just thought this guy. I love his approach. So my question for you then: why are taxi medallions judgment proof? Why are tax medallions judgment proof? Who would want that? Well, clearly we know who the Baptist is, the public figure. The taxi drivers. You own a medallion, you don't want to lose it. They're expensive. Who else cares that medallions are judgment proof? A medallion costs upward of $1 million. Yeah. How do you think our buddy Carlton got his 10 medallions? Think he had $10 million before he started a company? How do you get a taxi medallion? How do you get $1 million? Take out a loan. It turns out there's an entire industry dedicated to taxi loans. And so one of the biggest advocates for protecting taxi medallions are not the taxi drivers, but the banks. The banks are the bootlegger in this story. The banks are the ones behind the scenes. They want to protect their collateral. They don't care if people who get run over get hurt, not in that sense. They're a corporation. They have their narrow-minded interest of focusing on their profits. And those profits come from protecting that collateral. And we see this story of the bootlegger Baptists in the fight in New York against Uber. And we saw the story again, the same story as the Medallions. What happened in the fight against Uber? Well, sure, taxi companies. In fact, it wasn't even really taxi drivers that fought hard against Uber. It was really taxi unions. And that makes sense to me, at least, because truth is, if you're a taxi driver, if you like driving a car, you may not care whether you drive for Uber or if you drive for Yellow Cab, as long as you get paid more. And if the labor market is competitive, having a new entrant might actually be better for you as a driver. Maybe. But who opposed Uber behind the scenes? Who was the bootlegger in that story? Again, it was those banks who were worried that, in fact, after Uber went in, the value of a taxi medallion in New York fell from $1 million to $500,000. If you are a bank and you're worried about your collateral, this is a major threat to your business model. And so when you see something that doesn't make sense, when you see a regulation that just doesn't make sense, really $10,000 liability and a presumption that medallions are judgment proof, why would this regulation last for so long? I think the story of the bootlegger Baptist is a good thing to think about when you see a durable regulation. You have to ask, who's on the other side? I mean, I love the example they give about how environmentalists have actually made the environment worse by requiring clean standards. How does this happen? How can an environmentalist end up creating more pollution? Well, by requiring new standards, the question is on whom? Who will have to meet those new standards? The answer is new businesses. In general, the old production is exempt. Right? That's what they lobby for behind the scenes. And they go and they support the idea that in the future, new businesses that have power plants have to have these high-tech scrubbers and have to have low carbon emissions, which is very expensive. And so what does this mean for the current competitors? It means that no one can compete with them. It means that if you've got a coal factory from 1945, not only do you not have to put a scrubber on it, but someone can't build one up the road that's more efficient. And old coal factories, it turns out, are less efficient. They produce more emissions. And so one of the unintended consequences of some of these regulations, when misapplied, is that it can actually have the counterintuitive effect that by increasing the regulation on coal, you actually can increase pollution. And so it's an important story to think about, and I thought this case was a chance to bring that economic concept up. All right, we have just a few more minutes. We have one more case to talk about, and so this was Radiswicki versus Telecom Corp. And it's another accident case. So what happened here? All right, so our friend Radiswicki was riding his motorcycle. My dad calls them donor bikes, right? So I don't know if any of you drive one. Drive carefully, especially in the rain out here. And he was seriously injured by a truck driven by an employee of Constructs, right? I mean, driving a motorcycle is an assumption of risk, but he didn't assume this risk. What happened to him was that he sued Constructs, and he is an involuntary creditor. Now, the jury decided he was entitled to damages. He was not at fault. I mean, you take some assumption of risk by riding a motorcycle, but not the risk of getting hit by a truck and not paid for it. So the jury finds that Conrad Radiswicki is deserving of money. So what happens to the money? Well, Constructs doesn't have much money. It's not heavily capitalized. It's minimally capitalized like most businesses are. It's actually a subsidiary, but it has insurance. They had the mandatory statutory insurance. However, their insurance company went bust. And what happens to our friend Radiswicki? Well, he's left holding the bag, right? He's injured, and he's deserving of compensation. And the system is not giving it to him. So he sues. And he sues on the theory that he should be able to pierce the corporate veil in the upward direction and go after the parent company, Telecom. Telecom owns the insurance company as well, by the way, although that doesn't seem to make a huge difference here. So the question is whether, under Missouri law, Radiswicki could pierce the corporate veil and hold Telecom liable for the conduct of its subsidiary. And it turns out that the rules for a corporate parent versus an individual shareholder really aren't different. Right? This is a little different in that at the top of that is not an individual, but another company. But the court doesn't seem to care and finds that, no, we're not going to allow piercing in this context. Why? Because it wasn't being treated as an alter ego. It wasn't undercapitalized. It was minimally capitalized. It wasn't having any wrongdoing. It was operating properly. It had no reason to know. I mean, why would anyone buy insurance deliberately from a company that's going insolvent? That didn't make sense. There didn't seem to be any wrongdoing there. And the court cites a case that you should know of. Collett. Collett versus American National Stores. You don't have to cite to Collett. You can cite directly to Walkovszky, but it sets out 3 things a plaintiff has to show in order to pierce. So what is our 3-part test? First prong of the 3-part test is control. And not just any control, but here they mean complete domination. Complete domination not only of finances, but of policy, business practice, in respect to the transaction. So much control, in fact, that the burden is on the plaintiff to show that the corporate entity at the time and as to this transaction had no separate mind, was completely dominated by the parent or the shareholder. And 2, that control was used by the defendant, by the shareholder, by the parent to commit fraud or wrong, to perpetuate the violation of a duty or other positive legal duty. Okay, high burden, right? To actually show that that control was used to create wrongdoing. And 3, that control and breach of duty proximately caused the harm. So that's the 3-part test set out in Walkovszky, which is known as the Alter-Ego Doctrine. It is not the only way under which you can pierce. As I mentioned, there is no one standard for piercing, but this was a particular kind of liability called the Alter-Ego Doctrine, essentially saying that the subsidiary was not different from the parent at all, was completely dominated from it, had no separate mind or existence of its own, and that control was used to perpetuate, commit a fraud or wrong, and that fraud or wrong proximately caused the injury. That is the Alter-Ego Doctrine. So, Walkovszky argues that Constructs was undercapitalized, and that goes to the second prong. How is undercapitalization something that the defendant uses to commit fraud or wrong? Well, the district court agreed with the argument, so we can look to that for that and say the district court found that Constructs was undercapitalized in an accounting sense, and although it had some amount of money, it did not have enough to satisfy its debt in this case. So the district court took a very narrow view, and by the way, spoiler alert, it was overturned, took a narrow view and said because you couldn't pay your debts in this instance, they had $10 million in coverage and $1 million in basic liability, and that wasn't enough for reasons that turned out later in hindsight. The district court held that the federal regulation did not say what was enough, but in this case it was proven not to be enough with the benefit of hindsight. Well, the Eighth Circuit reversed and restored us to a state of the world that looks a lot like Walkovszky. The Eighth Circuit disagreed and said the whole purpose of asking whether a subsidiary was properly capitalized was to determine its financial responsibility. If the subsidiary was financially responsible, the part of the test, the second part, was met. If you're being financially responsible, you are not committing fraud or wrongdoing with your financing. And so insurance should be enough. In fact, insurance in some ways is better because it could potentially cover much more. I mean, if you have $100,000 in the bank, you can get a lot of insurance for that, depending on what you're doing. You might get $10 million in insurance versus $100,000 in the bank. That could really help our motorcyclists in getting made whole. And so they don't distinguish between insurance and cash in the bank, so long as they're meeting their requirements. And it was beyond dispute that Constructs had insurance, and therefore it was considered financially reasonable under applicable federal regulation. The court found the doctrine of limited liability was developed precisely for this situation, to protect a parent from a subsidiary who goes broke. To protect a parent whose subsidiary goes broke. That's the point of the doctrine. It would be destroyed if every parent corporation would be liable every time a subsidiary did not have sufficient funds. All that Walkovszky showed in this case was at the end of the day they didn't have enough money to pay him. Well, that happens. we can have a different conversation, going back to corporate social responsibility, purpose of corporations, whether that's fair that we allow corporations to externalize risk, but they do, within bounds. We have not exceeded the bounds yet. We still have not seen a case. Now, the senior circuit judge, Heaney, disagreed. Heaney argued that Contracts was just a shell corporation, and it was established by Telecom only to allow Telecom to operate as a non-union carrier. Contracts is driving around, they don't want to employ union people. Telecom, I guess, had union contracts or was susceptible to unions, and Judge Heaney actually argued that they were avoiding union laws. Now, I think that one reason that argument doesn't hold water is because it doesn't meet the third prong. What's the third prong? The third prong is that the control and breach of duty must proximately cause the injury. If Telecom set up Contracts to avoid paying union dues, did the failure to have union members cause the harm? That's much more attenuated. Now, it's possible you might find some argument that union drivers are safer. Maybe union truck drivers are safer because they get more breaks and are paid more, or what have you, or it's hard to be selected for, and so that would reduce the risk of harm. That argument was not successful. That's way too attenuated. And so I would disagree with Heaney in that he did not address the third prong of that argument. But, you get these kind of cases where you feel bad. Someone gets terribly injured in a motorcycle accident. You'd like to see them made whole. But I think the court rightly held, the Eighth Circuit rightly held, that that was not the correct result in this case. Undercapitalization is not inherently even unlawful. It depends on the reason for doing it, right? Going back to that alter ego test, the second prong is used to commit fraud or wrongdoing. Some courts have inserted a scienter, an intent requirement to that prong. Now, you don't have to necessarily go that far. Not all courts have adopted it, but again, there's not a clear standard on this, which means that piercing is more appropriate if a company is deliberately or recklessly creating a company that cannot pay its bills. If you're simply negligent and you don't maintain enough capital because you're dumb or lazy, that's not enough to rise to liability if we have a scienter requirement. Not all courts will take that approach. So is this different than the test used in Walkovszky? Not really. The result would be the same, but this one is a little bit more structured. And as law students, you may prefer a more structured test. Now you have one, right? You have three prongs that you can evaluate, one leading to the next. And so I would suggest that if you're going to address piercing in torts cases, you can adopt the alter ego test because it's a little easier than just throwing all the factors into a big soup as Walkovszky did, but either test would result in the same result. All right, so last few things. Yes, sure.
Quick question.
Yeah, of
How
course.
would vicarious liability factor into the whole control factor, the second prong?
Vicarious liability of the...
So, of an employer and agent, or what does not even matter?
So the vicarious liability would pertain to an employee and an agent within an organization,
Yeah.
but not. It does not. You would need a separate veil piercing to go up the chain. If, however, Telecom did more than own Constructs, but actually directed it, if Telecom hired a Constructs driver to whatever, and maybe said, we need to get that, I don't care if the speed limit's 60 and it's snowing, you're doing 80 because this shipment of telecom equipment needs to be delivered. There we could see an argument for liability, but here this was a totally separate operating entity, and so vicarious liability wouldn't apply since there wasn't that agency relationship.
So I mean, like between the parent and the subsidiary, that control needs to be there, period.
In order for there to be vicarious liability, you have to actually be directing a person to do a task, as opposed to simply owning a company, right? And so, I mean, likewise, like you're let's say you go back to Microsoft, you may be a shareholder of Microsoft, right? That's different. That relationship changes, however, if you start engaging with some member of Microsoft to do a certain thing. And so long as you maintain that appropriate role of the shareholder, sort of just voting for the board and electing them, the board then will make decisions for the company. And even their liability will be limited. The CEO who sent the driver out, maybe some liability for him there, and that's why we have insurance and things like that. So what is the argument then for enterprise liability? Why would we create a situation where you're liable for your parent companies? Well, it expands assets to corporate creditors without imposing liability on the shareholders. So some will favor enterprise liability, even if they don't favor individual liability, because it allows more collection, but it still doesn't go to individuals. We'll talk about that a little more when we get to corporate groups. But it doesn't actually matter in Walkovszky. Why? Because the other corporations in this economic unit were likewise undercapitalized, if you will, or minimally capitalized. So what kind of advice do you give your clients after learning this? Now, I'm not talking about contracts yet, different set of advice for your clients with regard to contracts, but if your clients are a corporation, or corporations, and they do things that can result in tort liability, what should they do to protect the shareholders? Well, let's take a look at the factors and flip them, right? What would we do? How would you advise, for example, the owner of a taxi fleet to organize the business? Well, one thing we learned in this multiple corporation structure was respected. You probably should have a different company for every cab and maintain the minimum amount of insurance, because apparently maintaining minimum insurance is enough. You're not undercapitalized, you're minimally capitalized, but that's enough. You don't have to worry if you're minimally capitalized, it's not undercapitalized. So we'd advise the client set up a multiple structure. In fact, when I work with clients who are dealing real estate transactions, I always encourage them to look at a series limited liability company, which allows you to do this without multiple filings. Talk more about that at a different class. But in any event, this multiple structure generally works, but it only works if the corporations act like separate entities. And that means that you need to observe corporate formalities, and you know how to do that now because what we studied in authority and how corporations grant authorities. That's a fundamental lesson that fits into here. If they're not observing formalities, much greater risk of having them commingled. And again, commingling, you don't want to be dipping in the till. Make sure there's that separate bank account, and not just a separate bank account between the owner and the companies, but that means if you want these companies to be treated separately, they each need their own bank account. Right? Any commingling can result in those two being seen as the same entity. So if you have companies A, B, C, D, E, and F, and there's only one bank account, you're now running a risk of having enterprise liability. And so you tell your clients, no, you need a separate bank account for all those cabs. That's more important even than having separate assets. They shared a garage, for example. There was some common plan to all this. That increases the risk a little bit, but bank accounts are the biggest thing. And you might tell the founders come to you and say, we kind of ran over this guy. I think a lawsuit might be coming. Can I issue a dividend? So no, that's a bad move, right? So if there is a big liability coming, a big contract coming due, you ran over a pedestrian, et cetera, and the client says, I'd really like to avoid liability for this. The company has $1 million. I really did this guy a solid, so I'm probably going to be hit up for that. Can I take that money and issue a dividend? No. We go back to some of the concepts about fraudulent conveyance there, but also if you're shuffling access, the New York court would more likely pierce in that case. So to wrap it up then, when we learn about piercing, we talk about these first two cases. How are they similar? Well, in both cases, we're talking about involuntary claimants. Tort claimants are, by and large, involuntary. And we're talking about operating companies that had minimum insurance. They were not underinsured. They were not well insured, but they had the minimum insurance required by law. In both cases, we had a wholly owned subsidiary dominated by a parent, right? Similar structures. And we find a conclusion that piercing is not appropriate. And I'll add to that, in both cases, we have a finding. We have no evidence of commingling assets. We have no evidence of not observing corporate formalities, and so we have the absence of those plus factors. There were some differences. Walkovszky is a parent to a corporation, and so even if there was piercing, shareholders themselves would not be liable, but that didn't seem to make a difference. We're still going to protect interest even for corporations. Walkovszky was really trying to get at an enterprise liability concept, but the court applied the same doctrine. Should we then, is this right? Should we protect corporate owners in the same way as individual owners? Well, the court seemed to. But you can think about whether or not you think that's fair. Because you can insert many levels of corporate interests, one on top of the other, like a set of, those Russian dolls. There's only the little one inside. Whereas there's a limit to how many natural persons can be sitting on top of this. And do we achieve the purposes that limited liability is meant to achieve by protecting corporations the same level as people? These are open questions. So then, why should the internal operations of the corporations be relevant for torts? I mean, it's not like the company authorized running over some guy, right? They didn't have a board meeting and say, okay, let's go run over Carlton. Let's go run over Walkovszky today. That wasn't an authorized decision. So why do we care about books and records? Well, some have argued that if corporate formalities are flouted, it signifies that the company is not being run as a business, but as an alter ego. And it helps the court give a reason to hold a person liable. It's kind of a quid pro quo. I mean, having a corporation is a bargain. You get certain liability privileges, certain immunities, and you have certain responsibilities for it. So while the argument does not hold as much weight as we'll see as it does in contracts, courts will still look at whether there has been a flouting of corporate formalities.